Thank you for your time to coming to this workshop, and a special thank you to and welcome to those that might be joining us by live stream. It's my privilege to introduce this workshop today. This is a joint initiative by both the Ministry of Justice, BTIB, and the Chamber of Commerce. And the workshop was originally developed to assist companies to understand the re-registration process, as was determined by those who developed and created the legislation that was passed by Parliament in 2017. However, due to recent developments, we've had to postpone the workshop to today, and we've had to update its content. It is envisioned that those that would most benefit from this workshop are those with companies that did not intentionally miss the 10th December 2020 re-registration deadline, whether you were struck off or in good standing prior to that deadline. Those that may be considering incorporating new companies may also benefit from the content that's being presented today. How we'll proceed is, first we'll hear from our Registrar of Registry Services, Rimmel. She will be presenting first on some background information and highlighting some of the changes that went into play with the new Act, and going over some of the new incorporating and annual fees processes. After her, we do have Tim Arnold, who will be presenting. He's not here yet, but we understand he's on his way. He was counsel for a recent court decision that just came out earlier this week regarding Sea Spray Enterprises. And so he'll be updating us on the impact of that decision moving forward. After that, we'll have a Q&A session, so anyone that has questions can ask them. We also have staff monitoring if there's any questions on the live stream to see if we might be able to address those as well. So we'll proceed accordingly.
So like what Tomato was just saying, we're just going to do a brief outline of the changes, some of the changes that happen in relation to companies. We will focus today, we will only focus on companies. So we'll look at the background, some of the changes, and the incorporation process. This is incorporating a new company. And then we will look at the annual filing process, and I understand most of us are at that stage current. So in 2017, the New Companies Act was passed by Parliament, and it was enforced on the 10th of December 2019. But during that year, 2019, we did consultations. Some of those consultations happened here, and we went to the other villages, and we did workshops here in Rarotonga, workshops in Aitutaki, and also we extended a workshop in Mangaya. And also the Chamber of Commerce did a public consultation as well, and we also conduct workshops with lawyers and the Chamber of Commerce, and also to the banks. And during that time also we developed brochures, and we made those brochures available to assist our public. And we advertised news articles, and we advertised advertisement, CITV advertisement. And also we put those on our website and on the online registry, and also on our Facebook profile. So we also managed to create YouTube videos that was available for the general public to see all those changes. And then the re-registration was free, and that was our whole year that Kevin
Just move the table further. Okay, let's continue. So within the 2019, and then
we launched the new act on the 10th of December 2019. So from that time, the 10th of December to the 9th of December 2020, that is the transitional period that was given to all companies to re-register. And the re-registration was, of course, free. And currently, during that time, we have a total of 900 plus companies that managed to re-register within that period. And also we will look at the payment options. So the payment options, even though the system was live, there was a delay in the online payment, but now we have managed to enforce that and implement it. And we have a POS machine at the MOJ now, and then we have cash payments available at the counter, and you can pay in advance and your fund will be credited to your account. These are our payment options currently at the Ministry of Justice. So some of the changes that are in the new Act, which are not in the old Act, there are shadow directors that will be under Section 96, 98, and then we have a default constitution, and then the process of annual filing fees or the annual returns, the term that I used in the past. So, a shadow director as defined under Section 96, 98 is a person not listed on the registry as a director, does not openly participate in decision making, but whose instructions are followed. This person is subjected to some duties and liabilities as imposed upon named directors. The rule intended to combat fraud or use of funds. And then we will look at the default constitution. Like I mentioned previously, in the old Act, we have the Memorandum of Association, Articles of Association, and then you have all sort of form the registered office. Now that the new Act have combined all those in one single constitution. So there are 3 standard constitutions available for you, which is a sole holder constitution, and then there's a constitution for companies between 2 to 9 shareholders, and lastly there is a constitution for more than 10 shareholders. And also you are given the opportunity to make your own constitution. So the incorporation process, and this is relating to a new company, if you are trying to create or register a new company. So the website is available. It's it's registry.justice.gov.ck. So the first step you have to do, you have to create a client account. So you visit the website, you click on the client account, and then you fill in the details. Within this client account, you also need an government-issued ID, which means a copy of your passport or a copy of your driver's license. So you upload that, and once you have uploaded, you will have to save to complete the application. So once you save, the application automatically comes back to MOJ, and one of the company staff will review, and if all the informations are entered correctly, we will approve that straight away. Otherwise, if the informations are not entered correctly and there is a spelling mistake, we will send that back to you for revision and resubmit that as well. And once you've done your client account, then you can go back into the system again and start completing the re-registration, start the registration process. So you have to enter your name of the companies, and then the directors, the shareholders, the addresses, and then there is an icon that will give you an option which constitution you want to use, and the primary activities, and then you make your payments. So you can, like what I said earlier on, you have payment options. You can either pay online or you can pay at the Ministry of Justice, and we can credit that to your account. So once you make your payment, you sign your name and then you complete the application. Once you complete the application, it comes to us and we will do the same. We will review your application, and if we need more information, we'll come back to you and request for that, and then you submit that to us again. If everything is in order, we will approve your application. So one of the thing with this new system, every time we make your request and then we approve, you will get an email notification to say that your account has been approved, and also your application has been approved. So you will get that a notification through your email address. So that's why when you make your application, it is important to enter an email address, because that's the address that the system will automatically forward all the activities that happen. So for the annual filing process, that's under section 338, 340 and 2343, and this is a requirement yearly. It's a yearly requirement for all companies to file their annual returns. Like what I said previously, you will get an email to say that your annual return is due, and then you can go onto the system and make that and upload your annual return.
Can I ask a question? I work at Brown Harvey, and we've incorporated a couple of companies, and the address linked to the companies is our office account. We haven't been getting the reminders about the annual returns.
Okay, for that, we have the companies that was due from January, February, March. There was an error in the system, and we have extended the annual filing date to June. So when it comes to June, we should be getting all those the reminders. Yes.
What's the time frame to send that email reminder out? What's the time frame? A month before or what? The reminder email? It's just that we've got companies due for annual return filing this month, 31st of this month, and
Like what I was just saying to Ina, not all the companies from January, I think December,
last year.
all those companies have been deferred to June. So that's why you're not getting any email reminder now, because the deadline for the annual return has been extended to June 18th. So you should get a reminder in June.
If I may add just to that.
Last
So
year.
you're saying
So
that
that's-
if ours is due the 31st of March this year, it's deferred to June.
Yes.
So there's reminders that are being sent by email, so we're fixing that. If you look up your company on the online registry and it says the deadline is a certain date, you can go ahead and still process your re-registration or annual filing. If there's technical difficulties with that, feel free to contact us directly.
Can I just point out, I did try and do that, but there was no annual return form available, and I sent an email. I don't understand, because it's the 1st of May, I've got quite a few companies, and I can't get access to the actual form.
Maybe we can see you after and then we can make sure that works.
Can I ask a question, please? I just wondered why the Justice Department shut the door for re-register. I know you had a year grace given, Because from 2019 to today, all businesses are dead. And I feel that the Justice Department should realize the burden of the business people. Look at it in here. We all have to re-register our companies, but the businesses were dead. And we were doing things to survive and not worrying about re-registration because we had no business to operate. Well, there were businesses standing, but I just wondered why on earth did the Justice Department didn't understand and give us another year grace. Up to now, we still haven't opened the border yet. We still got no tourists coming in. And we're going through such a huge, to me, unnecessary extra burden to you and us. I just wonder if there was any chance we can go back. I've been in business for 50 years. I cannot believe that I am no longer in business. Some companies are done, but one is not re-registered because my daughter does it and she was off the island trying to make ends meet. So this is really what I want to say.
So thank you for raising that issue. I know that's an issue for many people, and we'll try to address it during this workshop. I think it's best if we finish this particular presentation, then hear from Tim, who will update us on the recent judgment that came from the courts. Then we can address the question and any other questions we have.
Okay, let's continue. So like what I said, once a company is re-registered, your annual filing date will be the date you have re-registered your company, or you have an option to pick a date you want when to file your, you have that opportunity under our legislation to pick your own date you're comfortable with. And if you fail to file your annual return, you will be removed of the registrar after 6 months. So there is a grace period. If the deadline is today and you have 6 months to file your annual return. Otherwise, if you fail after that 6 months, the system will automatically remove you from the register. From the register. And if you are removed from the register, you can restore your company. And this is how you will restore your company. You can show that within 2 years of strike off, you can file back the overdue annual returns with fees and pay the penalties. And after 2 years, you can seek a court order to restore your company onto the register. Thank you. So you can ask questions, you can make comments. I think the 6 months you're referring to is your annual return. What your question I think is asking is to do with the re-registration period. So there's two different things. So the re-registration periods we're given 1 year to do that re-registration. So
What's the point of a return when you don't have no company to return?
So it's a legislative requirement. So we can't just change something without a authority to make a change. So we are following our legal requirements under legitimate companies.
So maybe what we'll do is, because I think the information Tim will share with us may have impact and may answer some of the questions we already have. So we can invite Tim to come forward and explain C-spray and the judgment that came about.
All right, well, te lana tuku katoa. It's good to be here. It's particularly good to be here in a church because, well, some of you I know have been praying in recent days over the future of your company, but speaking as a lawyer who's been in practice here from 1980, I would say, and not with a sense of irony, praise the Lord for a new Companies Act. So I'd really like to start by saying you should all be grateful that you have this new Companies Act. The old Companies Act went back to 1955. The documents that I've been involved in preparing and charging you people hundreds of dollars to form companies themselves date back to the 1930s, the 1940s. They were transcribed from the publications of the old Avon Publishing Company. The whole thing, to be perfectly honest, was Victorian. The only people that were benefiting from the old system were the lawyers.
Still now.
Well, there is a bit of bad news, which is, again, it's good that we're here, we're going to pray. But in the round, as you have seen, there is a system which is user-friendly to the point that anyone with basic computer skills ought to be able to form their own company. They ought to be able to run their own company. And they ought to be able to do that taking advice, as you always do with your accountants, because that's a whole yearly thing. The Justice Department is here, and yes, there are problems, but they're working their way through them. There are no fundamental problems with anything you've heard here today. In fact, before I go on to the bad news, which has propelled some of you here today, I do want to share with you just two things, because it's not all as good news as it might be with the new companies. On balance, we should be thankful, but there are two things you need to be mindful of. The first one is this. Rimmel talked to you about shadow directors, but the one thing that none of you have picked up on is why this Act's talking about shadow directors. Well, there is something very sad about the Cook Islands. You may not think this is sad, you may all think this is the most wonderful thing. We are one of the few countries in the world where you cannot be declared bankrupt. There is no law of personal bankruptcy. And I grew up, and until I came to the Cook Islands, I went through law school, and until I came to the Cook Islands, and I had been debt collecting for a few years, and I know these people. I won't embarrass them. Many of them have now died. But I know people, Cook Islanders, the spouses of Cook Islanders who came here, wanted to make a life here, went into business, and they failed. They failed, and every time they tried to pick themselves up again, their creditors were waiting. There is no relief from massive debt in this country. It does not exist. Bankruptcy at the end of the day is a protection for every one of you in this room that the government has decided you should not have. And in fairness to the government, when you heard me mention the word bankruptcy, I'm sure every person in this room thought, oh, that's a bad thing. There's only one thing worse than bankruptcy, and that's no bankruptcy. Now, is this something you need to worry about? Yes, because there's another thing that we share with places like Australia and the United Kingdom and the United States, but not with New Zealand. Okay? If you walk out at the end of today and you trip over there, then gosh, Jeannie Matenga, George Pitt, or whoever had better watch out, because the action for personal injury is alive and well and coming to get you in this country. Talk to Jet McCombie the next time you see him. Willis, Tower, or whoever. Personal injury will ruin you. Okay? Those of us that were running steam locomotives, frightening. But in those days, I had a company, Rarotonga Steam Railway. I was a director of that company. And that person could slip and fall in front of the steam locomotive. They could be chopped into little pieces. They could be an American tourist. They could sue for $100 million. But all they could do was get the company. I was a director, but under the old Act, I had the director's duties under the old Act. And I could say, sorry about that, I will try and do better. Now, those days are gone. The duties that are owed by directors of these companies are significantly higher than the duties that are owed by directors of the old companies. People like me that understand what that entails have had me resign directorships that are not necessary. It's no secret I was a director of Ingram Properties and JPI, Ingram House, the Bonniers building and so on. Do I want to be sued when somebody trips and falls? No, I don't. So, has the government led you down the garden path? No. The fact of the matter is these directors' duties are the same as they are in New Zealand for almost all practical purposes. But, moving forward, all of you need to risk manage your time and effort and the manner in which you perform as a director. Read the Act. It's designed to stop people being irresponsible as directors. And I've seen lots of irresponsible directors. I've seen one man form a company. Some of you will know who I'm talking about. He went to a firm in Winston's and he said, I want to buy a pre-cut house. Turnkey, more or less, for Rarotonga. Got the house, ordered it through a $2 company. It came up, went on his wife's land. It was an occupation right. We all know you can't get it an occupation right. And the house was built and he moved in and the people in New Zealand said, well, where's our money? He said, sorry, I don't know it. The company owes it. And that was very difficult. It was only the threat of the police coming along and saying this looks like fraud that actually got a result. And so, in New Zealand and elsewhere, people have said, we've had enough of that. The banks here have said, we've had enough of that. And so, you need to be more careful as a director in the future than you have been in the past. And I'd say, talk to Jet McCombie, talk to your insurers, because there is such a thing as directors' liability insurance. And you don't think twice about getting public liability insurance or fire insurance. And so the takeaway message, before I get on to this bad news, is these are great companies, but just be aware of that. And if you're worried about it, it shouldn't stop you forming a company, but it should have you looking a lot more closely at your director's duties. Now, I want to talk about where you will find what your director's duties are. And I want to go back to the Avon Publishing Company that I think was formed when Charles Dickens was alive. You heard about the Articles of Association that they've gone with these wonderful constitutions. They are good constitutions. I would recommend every one of you, as soon as you can, to form a company and use one of those constitutions. Every company that I've been involved with at the moment has used the default constitution. Okay? There's nothing wrong with them, so far as they go. But there was always a default constitution under the old Act. It was called Table A. The difficulty with Table A is when you read it, first of all, you needed to be a lawyer to understand it. And secondly, it was at the end of a very thick act, and you couldn't make sense of it unless you read the rest of the act. So the Avon publishing form was designed so that any one of you on a quiet Sunday afternoon could sit down and read from the beginning to the end, and you knew everything really that you needed to know in terms of responsibly running your company. Now, sad to say, although the constitutions are really good, and for someone like myself, it's not a problem, the new constitutions work the same way as Table 8. You have to read them together with the Act. And as we're about to hear, the Act is not entirely straightforward. It's written in plain English. If you went and found those parts of the Act that deals with directors' duties, you'd find it pretty simple to understand. But it is massive. And frankly, speaking as a lawyer that's used to fine print and reading massive documents, life's too short. You're asking, how could this happen? This problem we're about to talk about is because the Act is too big. None of us have looked at it as closely as we need to. But the good news is this: the dying gasp of the lawyers making money out of you all takes this form. For about the last 6 or 7 months, Heinz Manazik, Brian Mason, Karen Harvey, Tim Arnold, and anyone else that's interested has been taking the old Table A, taking the new 2 to 9 person constitution, putting them together, and we are going to end up with a document that on a Sunday afternoon you can pick up from one end to the other, and it will tell you all you need to know without having to read the 300 pages of Companies Act. All right? So those are the takeaway items that I want you to know about in terms of the Act generally. Now, on to the bad news. How did this happen, says Jude? Well, this Act was not drafted by anyone in the Cook Islands. It was drafted by consultants who had done very good work in other countries. Heinz Manazik, myself, and I think Tony Manarangi and possibly Brian Mason met with the draftsman at the very start because we didn't trust people to do this properly. But we left that meeting knowing that there were people that had A, done it elsewhere, and B, some of them were out of the New Zealand Parliamentary Council's office. I draw statutes, but I'm an enthusiastic amateur. People that come out of there are professionals. So, the Act was professionally written, but its sheer size was such that it was not peer-reviewed by anyone. And when I say peer-reviewed by anyone, yes, I had a look at this, that, and the other. Brian Mason had a look at this, that, and the other. Tamatoa, Rimmel, we all looked at bits and pieces. But to actually sit down and go from one end to the other takes weeks. It takes weeks to do it properly. I know. Okay? And so, for reasons no one can understand, and I think least of all the people who drafted the Act, reading the judgment earlier this week, are going, what the hell's happened here? But the idea was, and it's a great idea, the old Act had been going since 1971-72. There were hundreds and hundreds and hundreds of companies that might have been alive, that might have been dead, that might have had assets, that may not have had assets, who knows? So, I think the thinking was, all right, we'll pass the Act, we won't bring it into force, but people know it's coming. When it does come into force, we'll give people a year to get their heads around the fact that, hey, you need to re-register, and if you don't, it's last chance hotel. So, they said, if you haven't re-registered, that's the end of it. And the reason for that is all these thousands of companies, hundreds and hundreds, over 1,000, that date back to 1971-72. there needs to come a point where you say it is dead, it is buried, it is gone, that's the end of it. But the difficulty is, they said, if you haven't re-registered your company by the 9th of December, you were never going to re-register your company. Now, then what happened, because some of you have been on the website and you've seen, oh, I'm out of time, this is how I deal with it out of time. Indeed, I was going to come to this workshop to find out how I could re-register companies out of time, because I couldn't see how to do it. And I thought, somebody has the answer. So for a few months this year, people were using the provisions in the Act that says, oh, if your new company falls off, then you can go to the court and get it re-registered. And so there was a small handful that happened there. And it was only when it came to me, Sea Spray Beach Villas, you all know, some of you know Dorothy Kingdom. She's down in New Zealand. Her story is the same as many of you. She didn't find out straight away. She found out towards the end. She had difficulty accessing the website. And she had an added difficulty regarding the fact that they were in New Zealand. Slipped under the cracks. So she came to see me, and I passed this job on. It's a real simple job. It's one of these things, again, where lawyers make money, okay? So I passed it on to this gentleman who's dressed up in the suit over there and said, look, keep on it. I've done my lifetime's quota of these things. Bring it back on. So he produced the application, and I looked at it and said, no, that's wrong. Give it to me. So I put it down, and I opened the Act, and I went there, and I went there, and I said, this isn't right. We can't do this. Surely that's not intended. Because the frightening thing was, it says, if you're not registered by that time, you're not going to be registered. But here's the thing. Everything your company owns now belongs to the government. You see why I'm like round smiling, you know, the government's not the program. But look, in seriously, we're all going to maintain a sense of humour, all right? I really want you to maintain a sense of humour overall of this, because everyone has acted in good faith from the best of motives, okay? Mistakes happen, and this is what's happened here. And worse, those of you who read the decision that came out from the Chief Justice and Judith Potter this week, there are two other features. Firstly, the company's gone, but as a director, you've got all the liabilities that go with whatever's happening. And frighteningly, I don't think they're Myra Thompson Railway liabilities. I think they're the new liabilities, so you'll be scared about that. And the second thing is that the Act used a word, it says if you've not re-registered, you are a nullity. Essentially, you're gone. You might just as well be a hobbit, an entirely fictional thing that no longer exists. So, this was so awful that I said, and you can imagine Dorothea, those of you that know Dorothea, I told her I was coming to this workshop. I said, we're going to get sorted out, Dorothea, don't worry. But, you know, she was out getting sort of anti-stress pills and so on and so forth. We had other clients. I won't embarrass them by telling you who they are. But again, you know, the pharmaceuticals were coming out thick and fast, and everyone said, you've got it wrong. And who would trust a person wearing plastic sandals to get the law right? So I was then told I had got it wrong because other judges have been doing this. So I thought, well, we need to test the case. Because I really think I'm right. I had to talk to the Solicitor General. The Solicitor General was as worried as I was. The good news is that the Solicitor General went to talk to Mark Brown and sort of said, look, Mark, gosh, you've got a lot more property than you thought you had. Came as a surprise to the Minister of Finance. He himself did not regard the government as owning all this stuff. I mean, politically, it's disastrous. Are you going to vote for this government in the next election? Of course you're not. So the government wants it fixed. The government does not want your assets. How could this have happened? So the Solicitor General went through all the paperwork they got, went through all the explanatory notes that went to Parliament, went through Hansard, and we all agreed that whatever was going on here was completely unintended. Okay? And that we needed to see whether a judge could find a way out of the rabbit hole that I couldn't see and Stuart couldn't see. Brett Gibson couldn't see it. Brian Mason couldn't see it. Clarence Madison couldn't see it. So we were beginning to feel that we were down a hole that was fairly dark. So I filed this test case, pretty sure I was going to lose it. And not at all surprised when the judges came back and said, no, this is not going to happen. So, where we stand today, and the worst news, I guess, is this, that the banks, let's say BSP and ANZ, and foreign-owned, have all got due diligence protocols and so on and so forth. The alarm bells are coming up on the dashboard there because a number of their customers are nullities. What is the status of their securities? I don't see anyone from the banks here today, but I think we can take that as a good sign because I think they, like the government, recognise that this is an unintended consequence. So how are we going to fix it? Look, one of the things you do when you're drawing legislation and you wear plastic sandals is you think, I may have forgotten something, okay? And so one of the nice things about drawing legislation is that you can sort of take total control of everything, provided it's not unconstitutional. You can say anything. You know, I will have a new wife tomorrow, sort of thing. You know, whatever. And so, fascinatingly, and I've never seen it in 40 years of legal practice, there's a provision at the end of the Act and it says, hey, there's a lot going on here when we get this new legislation in. If we need to change the Act, we can do it by regulation. Now, those of you that know about Acts of Parliament know that they are passed at Parliament and regulations are passed over there at the Prime Minister's Department. We'd have serious difficulty if those things turned around the other way. But those of us that were lawyers looked at that and thought, well, this is just a transitional provision. They can only do it to just do these little things to sort out anything that's gone wrong in the middle. So the test case put to the judges, hey, what do you think about this regulation-making power? The judges came back and they said, well, there's got something going for it there. But here's the thing, the regulation-making power is not going to work. And the reason it's not going to work is that if we'd known about this, and none of us knew about it until well after the event, if in late November Tamatoa and Rimmel had realised they'd had this problem, and they certainly knew that there was always going to be a dash, you could possibly at that point have used the regulation-making power to push out the time to, I don't know, the 30th of June. But that should have sailed. And there's a principle, a principle of constitutional law that it's usually pretty difficult to have something take retrospective effect. You can do it, and we are going to do it. But trying to do it by regulation is pretty much a non-starter. And so we don't want to go there. All right? There are some other issues that we need to sort out as well. Some of you will want or will need to have audited accounts. Brian Mason was one of the people that had to look carefully at those provisions of the Act that relate to auditor. And again, he only looked at the Act, it was all in force and everything. But it seems legally impossible to get an auditor qualified as such under this new Companies Act in the Cook Islands. Such a person does not exist. So we can't move forward that way. We're going to have to get the Act fixed to do that. There are a number of other issues. I'll share one with you, as I've been telling you about Mark Brown and all this wonderful property he thinks he may have. But someone who thinks deeply about these things by the name, well, the initials TM, sort of white hair, and often seen in the land division of the court, mounting interesting arguments. Mr. Moore pointed out that as a result of what's happened, the Crown may end up with a whole heap of these old capital value leases that were the problems of each of these companies. And the companies, in many cases, they're defunct or they haven't got any money or whatever. The landowners aren't going to see them for money. But under the old Act, the government could say, whoa, no, this company's struck off, but we don't want that property. We don't want to deal with Travis Moore. Yeah. Under the new Act, it doesn't work that way. The government's got it. The government has the problems. Travis Moore is out there sipping champagne as we speak. Now again, that's totally unintended, and it is going to have to be. It's going to have to be sorted out retrospectively. It's probably going to have to be retrospectively taking effect from the date the Act first came into force. So, for all those reasons, we are going back to Parliament. Okay? When I say we are going back to Parliament, some of you, because I know some people love to find people to blame, and I know people love to hate lawyers, and I know in my heart of hearts I should not have been watching movies last year or the year before on Sunday afternoons. I should have been poring over the Companies Act to see what was wrong with it. But the legal profession have said, look, we need to be more proactive this time around. So, here's what we do. I met with the Solicitor General, who's very busy, as I'm sure you all know, and he said, yes, this is urgent, can you help? I said, yes. We both agreed it's not for us to take charge of the Act, because the Act is administered by the Ministry of Justice. So I immediately followed that up with a meeting with Commodore and his team, and they said, yes, let's get it fixed. So, here is the process. You can't draw legislation without a policy. Not a problem, we've got the policy. The policy is, let's get a better Companies Act. We've got a better Companies Act, we've just got to glitch. So, not a problem with the policy. Then we have to have something called drafting instructions. And they don't let anyone draft legislation. You can see how it can go wrong even when the best people do it. So the idea is you identify what you need to fix in the legislation, and you prepare drafting instructions. I'm familiar with drafting instructions because I receive them and I draft legislation from time to time. So I have agreed that I will prepare the drafting legislation. And as of yesterday, emails went out to all the shakers and movers with their little black books of things that were wrong and said, please think hard, what's wrong? We're going to Parliament in June to fix this. We're aiming at this point to have the drafting instructions ready for circulation among us towards the end of next week. Okay? Time is short if we're going to make the June session, and we have to make the June session. It may be that we actually draft it ourselves. When I say ourselves, there are lawyers such as myself that say, look, the best way to figure out if your drafting instructions are correct is to see what a clause might look like. Because it's only when you see the fine print that you start to ask all the little questions and throw up all the little answers. The phrase, the devil is in the detail, applies to drafting. But that won't slow it down, because the drafting instructions, I'll tell you where they're going to go. I told you about these people that were so expert, that had done it before, that had come out of the Parliamentary Council's office. Can you imagine how they feel right now? They didn't hesitate. When they saw the judgment, they said, we will do whatever is needed to fix it. How can we help? All right? So, we're going to move with speed with our drafting instructions. We can take as read that they are going to move with speed. We'll then move with speed because we very much like the idea of then taking the resulting draft to the Parliamentary Council's office in Wellington. Because again, the more people you look at legislation. Those of you that saw me running around with the Infrastructure Act in 2018, 2019, that's the way you do it. You just throw as many people at it, you ask as many awkward questions. Everyone needs an Andy Kirkwood in the room when you're doing things like this. Okay? In all seriousness, you don't ask the tricky questions, you don't pull out the principles that need to be put down on paper. So we're hoping to do all that. The main reason I have agreed to come today is because I knew you would all be here. Because the fact of the matter is that with the borders opening, the allure of overseas travel, the fact that our politicians are being confined like caged lions to the Cook Islands for so long, means that, is there going to be a June sitting? And if there is a June sitting, is it going to be a short sitting so they can get away? And if it's a short sitting because they have to pass the budget, are we going to be told that the Companies Amendment Act is not going to be passed until, I don't know, September, December, you know, but around there, moved into June's units by that stage. This is not a time for playing politics. It's not the blame game. It's not about being divisive. It's about fixing it up. We all need to rebuild the economy, and that requires a stable and predictable commercial environment. And I think everyone would agree that this current state of affairs does not tick those boxes. The one thing you can all do, even if you understood nothing that I said this morning, you are all voters in this country. Your Member of Parliament is answerable to you, and all of you should be knocking on the door of your Member of Parliament and saying, please don't play politics, get this fixed, and don't rise from Parliament in June until this is fixed. Okay? I'm done here, but I bet you've got some questions. June.
Right at the beginning, you told us we are not covered under the insurance policy if somebody has an accident, say in my hotel. They can make a claim, but I don't have to pay. What I want to say is all these years we've been paying thousands of dollars to the insurance company because that's what they told us. If you have an accident and your customer claim from the USA, you have to pay, so you're covered. But you just told us we're not.
I'm sorry, no, let me just clarify that. All of you are familiar with public liability insurance, okay? The thing is this, that you all pay a premium that's predicated on your cover. And if you're like me, every now and again you suddenly realise that, whoops, you forgot to pay the premium. So the cover lapses. All of you have read the fine print and seen, gosh, there's all these exceptions. So, June, yes, everyone has been advised by their insurers to get insurance for public liability, but it has holes in it. And it's through the holes that you've always had those liabilities. And up until now, with a company, and you being a director of a company, it's the cheapest form of public liability that you've been able to purchase in the Cook Islands. Those days are gone, and so you need now to have an extra layer of insurance that protects you as a director. Okay? So that's the point there.
Well, I have a few questions.
Yeah.
Please bear with me. The first one was, well, I'm not sure whether you covered it. I wanted to ask, where was the Crown Law in all this? All these years, we have a Crown Law that should know these things. And don't answer it, please. And the other one is, we need to operate our business right now. Can the Justice Department allow us to take off the nullity piece of whatever it is, let us carry on our business, and don't tell us that we are no longer in business, because if that's the case, the government owns everything. We don't have to pay the tax, we don't have to pay the turnover, we don't have to pay the debt of the bank. Well, is this simple enough? Then on June, whenever the government's going to go to Parliament, and I don't even know who's our Minister of Police, by the way. our Justice Department, I'm not even sure whether he can read. I won't say anymore.
Okay. All right. Well, as to the first question, I have been in practice here since 1980. I struggle to think back to where we've had a harder working, more talented Crown Law Office than the one we've got at the moment. Okay? But here is the thing. Company law is a specialist area. I know this because I have, over the years, drafted a number of amendments to the International Companies Amendment Act. I was brought in at one point because there was talk of completely redrafting that from one end to the other. There was never any question of the Crown Law Office doing that. Their specialty is public law, criminal prosecutions, and so on and so forth. So the usual practice, the competent practice, is to identify a skilled professional with the qualifications and the experience. If we were to wave a magic wand and go all the way back to 2015, 2016, when this thing started, and if I was in the room then, it was upstairs behind MedFab, knowing then what I know now, I would still say they were the people to do it. Because the point is this: I know lots about the Cook Islands, but I don't spend all my time studying all the different companies legislation all around the Pacific and in New Zealand and Australia. You find a specialist and you put your trust in the specialist. That is what Crown Law did, and they can't be criticised for it. Okay? As to your second question, I'm sure you've all seen the movie. And it starts out, and then things start to go wrong, and they go worse, and maybe it's The Wizard of Oz. I forget the plot of The Wizard of Oz, and that went pear-shaped in a fairly big fall. But right at the end of the movie, all of a sudden, the scene changes and you realise it was all a dream. Okay? It never really happened. Now, I told you that one of the nice things about drafting legislation is that you can, legislate for a new wife apart from anything else. You have within constitutionally constrained limits absolute sovereignty. Parliament is absolutely sovereign. If it passes legislation to say that Darryl Leatherby is going to colour his hair orange, that's unconstitutional because he has a constitutional right to life, liberty and security of the person. But the problem we're faced with at the moment is that the Crown has a whole heap of stuff that it shouldn't have. Not private individuals, the Crown. The Constitution is to protect you people from what the Crown's up to. Okay? So, the Crown is saying, we're going to fix this. And so the Crown is saying, if you want to wave a magic wand and pretend this never happened, we don't have a problem passing legislation to that effect. Tamatoa does not hold that magic wand. Tamatoa has sworn to uphold the laws of the Cook Islands. Okay? Which means that he has to obey what Parliament has told him to do in the Companies Act 2017. He has been told, as has Rimmel, that they have to, they are legally obliged to treat these companies as nullity. And they don't have to take my word from it. I've got plastic sandals. They've now got the Chief Justice, and they have Judith Potter, who said it's a nullity. We can't do anything about that except hold hands, see the funny side in it. It's not that your business does not exist. Your business is still there. Somebody has to run it. Mark Brown knows how to run chip shops. He knows how to run the country, but he does not know how to run your business. So you're the best person to run your business. If you get into an argument with your banker, those of you that have got a loan, the bank just wants the money to keep coming in. The bank will be as embarrassed as this as everybody else, but you, as they said in the Blitz, and you've seen it, keep calm and carry on. Okay? Eddie?
I've been dealing with PSP in the companies
Yep.
the last 3 months, if I get registration, and they gave me deadlines and all that. And thank God to your decision that came out on your case, and I forwarded that to them yesterday. And the response was, yes, we are fully aware of what's happening, and they expect there should be a change in the registration to amend the bonds. And they said, we'll wait until that happens. So, which means a lot more than the announced conversation.
Yeah. Thank you.
I'm not sure, maybe I missed it in the paper, but for the previous 8 years or so, there used to be a reminder that without giving you 3 months to re-register your company, or else it will be struck off, and then another 1 month to do it, or you'll be struck off. And I think if that was published, which maybe it was and I missed it, but if it wasn't, I think we wouldn't have people here in this room.
Look, you make a very fair point there. It does come back to something I've explained previously. All of us in the room have seen those ads and go, oh, gosh, is my company there? You see them every year, your heart skips a beat. Mine does, because I'm the number of client companies I'm supposed to be keeping an eye on. But this occasion was different. Okay? This is not the annual go-round. This is a one-time migration of absolutely every single bit of the ball of wax that was the company's regime from 1971 through to 2010 to pull it over into the new Act. And so there were notices, and I understand why they didn't set out the names of all the companies, because it would have been as long as the Cook Islands news itself. You'd have been saying, look, it's midnight, when am I going to see the second part of One News? It would just not have been practical to have numbered those thousands of companies. It would have become meaningless. In fact, they basically said, look, if you've got a company and you want to get it re-registered, it needs to be done by this date. And again, with hindsight, and I'm sure Rimmel and Tumblr would say, with the benefit of hindsight, maybe we put some more ads in, maybe we would have picked up some more. But I can tell you this, you would not have got all of them. And I say that because I've been putting companies back onto the register, companies often with assets worth hundreds of thousands of dollars that have been struck off for 1 year, for 2 years, for 3 years. And then eventually somebody wakes up and goes, oh my God! So we have to go off to the court, and the judge says, well, didn't you notice this for 2 or 3 years? And the answer is no. So there was always going to be a pool of people sitting in a room like this, addressing the issues that I am now sharing with you. Okay?
Thank you for enlightening, but can you tell us a bit about if you're going to be redrafting, what do you know, have an idea of what the likely process will be when that is redrafted? Like, what do people in the room actually have to do come that time?
Yeah.
And secondly, is there something in the interim that some authority can publicise that says until that amendment happens, it's okay to be struck off, essentially, and you are still operating?
Okay. Right. There are problem companies in 3 distinct categories. The bulk of those companies were immediately before the deadline, alive, well, and in good standing under the Companies Act 1970-71. So the vast bulk of them fall into that category. There is a second category of companies, and I've just told you about those. They got struck off, last year, the year before that. They're the walking dead. They don't know that there's no company. They're just carrying on. They haven't quite figured it out yet. Interestingly, the Act uses a phrase, existing company. And those companies weren't existing companies. It's hard to see how they could ever have migrated. So that's the second category. And then we've got a small, very small, there's only a handful of companies in this case, where Tony Narangi, I know, has managed it on a couple of occasions. Heinz managed, they indicated that they had some put through. But as Rimmel knows, there are a number of companies since December of last year that did make applications to the court, and the court said, yes, you can re-register. The reason I brought the test case was that I could see no jurisdictional basis for those applications to have been made or granted. And the reason for the test case was to politely suggest that maybe people had got it wrong. And the polite answer from the Chief Justice and Justice Potter is yes, those companies themselves they don't exist, despite the fact they've got the order, despite the fact they look as though they're on the register. So, when you're asking what form is this going to take, no firm decision has been made yet. For myself, for the reasons I've stated, I think there will remain an obligation for you affirmatively to do something. We can't have all these thousands of companies from 1970-71 that, as it were, automatically migrated over here. A lot of them are dead and buried. Okay? A small handful of them in years to come may have to come to the court to be able to be re-registered simply because they've got, I don't know, the most common occasion is where there's an old lease that nobody's taken any notice of and somebody wants to do something and the company is struck off years ago. But what I believe is most likely is that statutorily we will deem all of this never to have happened, and having waved the magic wand to make the problems disappear in that sense, we are going to set a new date. So when people say, can't we have a new date? I'm sure the court is not attracted to having to deal with 1,000 applications from people that are in this position. The court will say that's not a good use of people's time. Isn't the reality of the matter and the common sense approach that we just say, okay, Parliament now says it's open to, I don't know, November the 30th, 2020. So I think that's the most likely position there. There is a difficulty with regard to those companies that were struck off under the old Act, that now want to get back on. And I think it's most likely that that smaller number of cases will have to demonstrate the justice and the appropriateness of being let on. There is a policy decision that somebody has to make, not me. Under the old Act, if you fall off like that, you've got to go and make the case to the court. The registrar has the ability to object. In practice, the registrar never does. The registrar says, hang on, you owe all these filing fees and so on and so forth. Under the new Act, it works pretty much the same way. You can get back on, but there's a process to go through, and you have to pay fees that you have otherwise sort of opted out of. It's a big thing in the International Companies Act because the annual license fees are like $1,000 US a year. And so the idea that people can get themselves struck off for 3 years and then just come back on again and miss the fees is, deprives us all of tax revenue. So I think what we will find once the policy decision is, are we going to involve the court in that, or now we all understand what's going on and it is this one-off special sort of process, can we, it would most likely be a discretion that's vested in the registrar if it's decided to do that way. And who knows, you know, the registrar in the first instance, or if she's got doubt, she can decline and then you've got a right to go to the court. So the idea is to make it user-friendly so we have this transition. Okay?
So the forms that are currently on the Justice website for readmission, at this point are we saying that we just ignore those because they're probably not going to be part of the solution?
Well, I can't speak to those forms because I haven't studied them. I would suspect that they have been drafted around the reinstatement provisions in the Act, and they relate to those people that don't file an annual return in June or July, and they fall off later this year. So I would imagine those forms are fit for that very narrow purpose, but they're not going to work to deal with the problem we've got here. It's most likely that the amending legislation, if it's felt necessary, will have a regulation-making power that says, look, and you're authorised to have the required forms up to give effect to this.
You give me the impression the new Act is faulty. Can we go back to December the 8th, 2020 and re-register everybody under the old Act while the government is sorting out the new Act?
No, the old Act is repealed. The old Act is gone. We wouldn't bring it back, and frankly, we wouldn't want to bring it back.
Sorry, I'll reword that.
Yeah.
I'm talking about the registration of companies. Can we go and re-register using the old system that Tamatoa, the Justice Department, had? Because right now, you just told us, those who re-registered, gone through the lawyers, is not legal.
Yeah.
I'm trying to simplify things.
No, the reason I stated, the judges have now confirmed what I thought. Parliament has commanded these two to do none of that. If they were to do as you're suggesting, they would be breaking the law. Okay?
What I mean is they approach the Prime Minister, the Minister of Justice, sit down, and the leader of the Democratic Party, this is a national issue. We're talking about the welfare of the country.
Yes, but that is a conversation about when can we next have Parliament sit. Because it is only Parliament. Parliament is supreme subject only to the Constitution. It trumps Mark Brown, it trumps Tina Brown, it trumps the Ministry of Justice. And so the road ahead leads straight to Parliament.
So am I just to understand that if we had previously been in good standing prior to being struck off, so all we've done is miss the deadline,
Yeah.
struck off, but previous to that we were fine,
Yeah.
is the suggestion that going forward, we just wait for this Parliament sitting?
Yeah.
So we don't do anything, we status
You
quo.
just carry on your business.
We know we carry on, but
Yeah.
in terms of, we know that we're not registered, that's fine because you know it's in the hands of professionals to fix. So in terms of anything else, we just carry on. Once the problem is solved, hopefully as per what you suggested is going to happen, then there's going to be ideally a new date set, and we have until that time to register as if we hadn't been struck off.
Yeah.
Is that
That's it in a
understand?
nutshell. Yes.
Okay, thank you.
So, what about doing another grace period again, rather than imposing another fee or re-registration extension of grace period of re-registration or
Maybe I can impose that.
Yeah.
So the re-registration process that was in place during the one-year period, there was no re-registration fee. So essentially, companies had 1 year free annual return fees at the time you didn't have to pay it. So I imagine what will likely happen is, if extending that deadline, the re-registration, there will not be a fee associated. So that's what I anticipate.
Can you part of the question, because I think there are probably a lot of directors in the room who talk about directors' liability. Just in the interim period, we're all going to stay calm, but in the interim period, is there going to be something that's actually publicised from whatever authority is appropriate to say that it's actually okay to continue as you are? Because there are other stakeholders, not just banks,
Yes.
not just anything, but there are donor bodies and other people that are
Yeah.
coming into the economy to try and get funds in here. And this actually is affecting some of that compliance work.
Okay. Look, like COVID-19, this is a fast evolving situation. And like COVID-19, it is a multi-agency issue. I don't own the problem, I don't own the solution. Tamato's got more ownership than I do, but he doesn't have total ownership. I've been, as I like to think people are with COVID-19, as open and transparent as I can be. I brought the test case to see if there was a problem and what the size and nature of the problem was. The question was answered by the judges only on, I think, Tuesday of this week. It is now Friday. In that period, I have A, spoken to other lawyers, B, off the back of that, spoken to the Solicitor General, who says, look, I don't have total ownership in this either. Talk to Tamato. So talk to the Solicitor General, talk to other lawyers, talk to Tamato, now talking to you people. The banks are already there. So what we need to do is we just need to get the news out. We then need to get to a consensus position as to how we're going to portray this to the rest of the world. I mean, the last thing we want is a breathless Barbara Dreamer. Promise economic recovery, yeah. So, no, you're quite right. We are going to need to put this in a box, messy though it is, and say this is what it is. But I can't unilaterally do that without, I don't know, treading on the bank's toes. The banks can't agree with something until a coherent position is communicated by them from government. Government can't communicate a coherent position until it knows the extent of the problem and gets advice. So in a sense, I'm talking to you, but in a sense, you are informing both me and the government reps here. So we are going to carry on, we're going to keep calm, and we're going to plot the way forward. And once we know how we're plotting the way forward, because a number of you will be having sleepless nights over this, and I would be lying if I said, oh, there are going to be no inconveniences. It's going to be irritating and frustrating at the very least from time to time. So naturally, if we can work out what it is and what it isn't and how we're going to deal with it, that will be communicated. All I can say is that I've been invited to speak here today. I do not have some overarching authority to speak on behalf of the government. I'm a private practitioner who's just, with the help of Dorothea, said, look, let's see what's wrong here and let's see how we can fix it.
My vision is that progressing towards justice is the tax department going to be treating these companies as companies?
Oh, I can answer that. I've always got these risque examples, but I took revenue law at law school, George Hine, and it was always after lunch, and I always found myself falling asleep. But I remember being sort of suddenly awoken as the astonishing proposition that was put to me that although it was illegal, the earnings from prostitution were taxable. The tax man is not concerned with the legality. The tax man is concerned with the commercial reality of what's going on. And accountants in this room will be familiar with that idea where the land belongs to treat the buildings as being the property of the company, even though we lawyers know that the buildings form part of the land. And so that's an example of the tax department looking at the commerciality of what's going on. So I'm sure in the tax department they're having a bit of a giggle in all of this because they have enough problems of their own, Helen, without investing in this one.
Just, so your suggestion to us here is that we go home, go online, and try and re-register our company?
No.
That'd be
No.
nothing?
No, you are unable to do that. There is a re-registration form on there, and when I was last there was advice telling you how to re-register at the time. I'm here to tell you that the Chief Justice has said, even if you were successful, what you end up is a no legal thing. Okay? So just carry on and await further instructions. Yeah. I'm sorry, can you speak up a little louder? No. If you've successfully migrated, you just keep calm and carry on in the same way. Secure in the knowledge that whatever this problem is about, it doesn't concern you. Okay? What it will do is that it will cure a few little glitches. Remember, if you successfully made the transition that you need audited accounts, for instance, you may have some difficulty satisfying your bank, or if it's an overseas aid agency or something, that you've had a proper audit under the Companies Act, because no one can be properly appointed as an auditor under the current regime. But those are issues that are going to be fixed. Okay?
So if you want to go and borrow some money from the bank, but you can't say to the bank, this is the company, but it's non-functional. That's...
I would be lying if I said that's not going to be a problem. Okay? I haven't detected any examples of that, but I imagine that what the banks are likely to do in those circumstances is to say, look, we'll hold hands with you, but I would imagine they would continue existing banking arrangements by way of overdraft or whatever. The idea that you could, while you were struck off, give a valid mortgage and take a significant loan is something that the banks are probably going to have serious indigestion over. But again, that's why it needs to be done with you. That's why you don't go and ask the bank that question. You go and ask Selina, you're not going overseas in June, are you, Selina? You're staying here until...
Sorry, I just got one last question. I have some clients whose companies were struck off, and a couple of them went in and created the new company, really quickly, thinking that they were dead. So in that scenario, I can say to them, just wait and carry on with the old one. But now they're going to have a problem that you're going to have new ones on there which were kind of set up in a panic mode that are not going to be used going forward.
Yeah.
So how do they get business?
All right, look. Various people have said to me, why don't we just go out and form a new company with the same name? If, in fact, your company is doing nothing more than protecting the name, then you would do that. But you need to be very clear about this. Your company isn't you. Your company is a separate person. And so your company has assets. And I know I've been joking around a great deal about this, but in all seriousness, the assets of the old company are currently the legal property of the government. And you can form all the new companies you like, and you continue to operate thinking, well, the government's not going to come and answer this. The difficulty is that if you afterwards want to deal with that property, to sell it, you can't give good title to a purchaser because your company no longer has title. The government has title. And so therefore, the idea of just going out and forming a new company is sadly not going to cut it. I'm not saying you can't do it. It may be necessary to form a new company for a limited time to trade on on a short-term basis while this is sorted out. The particular legal advice and accounting advice that you receive may say this is the best way to deal with it. But for most people, the key is in getting the consensus position communicated by the government, getting the legislation drawn, keeping calm and carrying on with the status quo, and be trustful that the magic wand will be waved and all, by the 30th of June, hopefully, all of this is just a bad dream. Okay?
If this was in the private sector, and I did something like this, I'd probably be here up before. I mean, at the end of the day, this is unintentional, but it seems that government now owns CDS, so putting things right. Was it intentional? Why is it that he's not involved? Because we know in a private business, we get something, he did something like that, he's gone. This is not good.
Okay, well I can answer that in 2 or 3 parts. Well, firstly, it was not intentional. Secondly, it's been a principle of English law that goes all the way back to William the Conqueror, that essentially, if assets become free-floating, if they become detached from ownership, they become what is called bona vacantia, vacant goods. And the law has been that the Crown holds bona vacantia. If you recall those words, B-O-N-A, and then vacantia, T-I-A, Google it and go bona vacantia New Zealand, you'll see that the New Zealand Treasury's got an entire website that sets out how you can apply to get your property back off the New Zealand government. So it's not a fraud, it's not a rort, it's to make sure that property always has an owner. And so, again, I was joking about Travis Moore. In that situation, you can see having the lease is a liability, not an asset. But it's this idea that property should not be free-floating, it should be owned by someone. So, not a fraud, very good reason to say why that should happen. As to whether heads should roll, look, at the end of the day, the people in the Cook Islands made, I believe, proper professional decisions, A, to update the company's legislation, B, to outsource that work to experienced and qualified professionals, and C, insofar as they got it wrong, and insofar as their client, the Crown, may suffer a loss, then there may be issues between them, but it'll be their heads that are on the block. I'm sure at the moment they're following the advice of their insurers, which is you don't admit liability. I'm sure they've said to the Crown, dear me, we don't admit any liability, but this is most unfortunate. So they'll be feeling very embarrassed and they will be working hard to put it right. There won't be any charge, I'm sure, for the drafting work that they do. But you're right, things do work slightly differently in the public sector to how they do in the private sector. That's the way of the world. Okay, well, I have far too much to say, so thank you for putting up with me.
I'd like to thank Tim for the time and for eloquently explaining some of the issues. We have no questions that's being presented on the live stream, so we'll go ahead and close. I anticipate that we'll give further updates as we progress the solution, and as we do a re-registration, a new deadline, we may have more workshops to make sure everyone gets on board. So if I can ask Rimmel, our registrar, to close this report.
Gracias. watu. Amen.